What would happen if one parent does not bring his or her child for a court-ordered custody exchange? First, we need to learn and understand the term for violating a court order. That term is contempt of court. In Utah, one commits contempt of court in a civil proceeding, like a child custody case in a divorce or between unwed parents, if and only if all the following criteria are met. As a general rule, in order to prove contempt for failure to comply with a court order, it must be shown that the person cited for contempt knew what was required, had the ability to comply, and intentionally failed or refused to do so. The district court must make explicit findings, whether written or transcribed, on the three elements of contempt. In a civil contempt proceeding, those elements must be proved by clear and convincing evidence. See the 2020 opinion of the Utah Court of Appeals in the case of Kohler v. Allen, volume 466 of the Pacific Reporter 3rd, page 738. So if the parent did not meet the child custody or visitation parent time exchange requirement because his or her car was out of commission, or because the flight home was delayed for weather, or because he or she was in a coma, you get the idea, then that parent couldn't be held in contempt because A, that parent did not have the ability to comply, at least at that time, and B, did not intentionally fail or refuse to comply with the court's order. That parent cannot be held in contempt. If the parent could comply with the order and intentionally violated the order, that parent can be held in contempt. To hold a parent in contempt, you would need to file a motion to hold the parent in contempt. You could move for, but are not required to move for, sanctions as well against this parent for his or her contemptuous actions. I have provided as a link in the description section of this video a link to where you can find the forms for this purpose if you want to file these motions yourself and the associated documents instead of retaining the services of an attorney to file and prosecute the motion for you. Warning, rarely do people who aren't attorneys fill out, file, and serve these forms correctly, and oftentimes a winning motion is lost because of it. But you have that option. What kinds of sanctions can the court impose for contempt of court for noncompliance with the child custody and parent time orders? Well, see Utah Code Section 78B-6-316, which provides that if a court finds by a preponderance of the evidence that a parent has refused to comply with the minimum amount of parent time ordered in a decree of divorce, the court shall order the parent to A, perform a minimum of 10 hours of compensatory service, and B, participate in workshops, classes, or individual counseling to educate the parent about the importance of complying with the court order and providing a child a continuing relationship with both parents. If a custodial parent is ordered to perform compensatory service or undergo court-ordered education, there is a rebuttable presumption that the non-custodial parent be granted parent time by the court to provide child care during the time the custodial parent is complying with compensatory service or education in order to recompense him for parent time wrongfully denied by the custodial parent under the divorce decree. The person ordered to participate in court-ordered education is responsible for the expenses of the workshops, classes, and individual counseling. The sanctions that the court shall impose under this section do not prevent the court from imposing other sanctions. All right. What else can the court order? Utah Code Section 76B-6-310 provides that the court shall determine whether the person proceeded against is guilty of the contempt charged. If the court finds the person is guilty of the contempt, the court may impose a fine not exceeding $1,000, order the person incarcerated in the county jail not exceeding 30 days, or both. However, a justice court judge or court commissioner may punish for contempt by a fine not to exceed $500 or by incarceration for 5 days, or both. And you can ask for the court to award you the fees and court costs you incurred in having to prepare and prosecute the motion to enforce the domestic relations order, and for sanctions as well. So maybe your next question is, all right, well, that sounds like a lot of work, so shouldn't I just call the police? Whether to call the police depends on circumstances, but generally I discourage calls to the police simply because a parent refuses to obey a court order to meet to exchange custody of the children. If there is a real concern that the parent has absconded with or kidnapped a child, a call to the police is more than warranted and appropriate. But calling the police in the hope that they will coerce or intimidate a parent into complying with the custody or parent time exchange orders usually doesn't work and often makes you, if you call the police, look spiteful. And it upsets the police. They feel they have much better things to do than respond to calls of non-compliance with child custody exchange orders. Better, in my opinion, to report the non-compliance to the police by calling them, reporting the non-compliance with a brief description of what happened, and then asking the police department to make a record and give you the incident number for that report. That way, if and when you move to hold the contemptuous parent in contempt, you have proof that you were complying at your end and did complain to the police about it. But I thought that non-compliance with child custody and parent time orders is a crime, you say. In Utah, it is a crime. See Utah Code Section 76-5-303, titled Custodial Interference. But with extraordinarily rare exception, law enforcement officers simply refuse to enforce it. I've never witnessed anyone being arrested or even cited for it. I've heard it's happened, but I've never seen it. Better to report the non-compliance to the police by calling them, reporting the non-compliance with a brief description of what happened, and asking the police department to give you a record and an incident number for that report. That way, when you move to hold the contemptuous parent in contempt, you have proof that you were complying at your end and did complain to the police about it, showing that you were trying to enforce it without court help and why you have to resort to court help now. That way you've documented the non-compliance and your reasonable efforts to enforce it to the extent that the police are willing to do anything connected with enforcement as well, which is admittedly very little. What if this is a chronic problem, you may ask? In other words, the other parent repeatedly doesn't show up for exchanges. Well, if the other parent is shamelessly flouting the custody and parent time exchange orders, and if you have a long enough history you can prove, and you can prove the no-shows are intentional, that could, if it's egregious enough, constitute a basis for a modification of the child or parent time or child custody awards themselves. If you can prove that the chronic non-compliance constitutes a substantial and material change in circumstances upon which custody was awarded, and that a modification is in the best interest of the child, to remedy the problems being caused by these substantial and material changes in circumstances, then you can see the case of Hudima versus Carpenter, which is a 1999 case in the Utah Court of Appeals. You might prevail on such a petition.